Thank you for joining us. I'm Kalina Eck.
And I'm Carrie Chilton. We're staff attorneys with the Disability Law Center of Virginia, and we'd like to tell you a little bit about eligibility for special education services, how the school identifies which students are in need of special education services.
First, let's take a look at the child find process and how schools identify children with disabilities who are in need of special education services. So school divisions have a duty to kids who live within the school division's borders. From birth to age 22, school divisions have to identify, locate, and evaluate students they think might need special education or related services, like speech therapy.
Practically speaking, how do schools learn about these children? It all starts with a referral. A referral can be made for any child aged 2 through 21, and it can be made by any source. So a child's teacher, parent, doctor, therapist, coach, or even neighbor can refer a child for evaluation. This referral must be made to the special education administrator. Often this is the special education director of the school. The referral must include the reason why the evaluation is requested. So, what is the referring source observing that makes them think a child may need special education services? The referral also must include what efforts have been made to address the concerns. This does not mean that everything or anything at all has to be tried before making a referral. The purpose of this is to catch a school up so they know what is going on and what has already been attempted. Federal law states that the referral must be in writing, but Virginia regulations relax this requirement and allow a referral to be made orally. We always suggest that any request be made in writing so that a parent can keep a copy of the request for their records.
Once the referral is made, a team assembles to determine what to do next. This team is made up of the referring source, whoever made the referral, the parent, the school principal, or whoever they designate to take their place, at least one teacher, and at least one specialist. They consider alternatives prior to going through evaluations. If this is an issue with a simple solution, say a student who just needs pencil grips as opposed to a full course of occupational or physical therapy. But there may not be any realistic alternatives. The team ultimately decides to accept the referral and move forward, or deny the referral. If they accept the referral, they have to tell the special education administrator within 3 days of the meeting. If they deny the referral, the team has to give the parent something called prior written notice, which we will talk about in more detail in a couple of slides.
Now we'll go over the timelines for the eligibility process. First, the school receives the referral. They then have 10 business days to meet and determine whether or not they will evaluate the child. The team must make a referral to the special education administrator within 3 business days from the decision to evaluate. Finally, the school must complete evaluations and hold an eligibility meeting within 65 business days from the decision to evaluate. If the school team decides to not evaluate the child, they must provide the parent with prior written notice. Prior written notice is a summary of the school's decision. Prior written notice must also be provided later on in the IEP process, whenever the IEP team decides to change an IEP or discusses a proposed change. The prior written notice must state what action was requested and denied, or was requested and accepted, why the action was accepted or denied, any alternatives that were taken or considered, the reasons why an alternative was accepted or rejected. The school must also explain what evidence was relied on in making this decision. Finally, prior written notice must address a parent's right to dispute the decision. Parents should make sure that everything discussed at an eligibility meeting or IEP meeting is included in the prior written notice. This document can be an important piece of evidence when pursuing dispute resolution options, so parents need to make sure it is complete. If a parent disagrees with something stated in the prior written notice, or something is missing, parents should ask to have the prior written notice amended, or write their own letter of disagreement and ask that this letter be included in their child's educational record. One last thing to note. Parents often wonder why a prior written notice is provided to the parents at the end of the meeting. The word prior means prior to the action being implemented. So prior written notice is provided after a decision is made, but before it is acted upon.
Another thing that pops up for the first time at this stage are the procedural safeguards. These are just part of the regulations that talk about things like parental consent before any changes are made, confidentiality, the parent's right to participate in the process, the right to independent evaluations, which we'll talk about a little later in this video, that sort of thing. Parents have to get a copy once a year at the initial referral or request for evaluations, and when they file a complaint with the Virginia Department of Education or file for due process. These procedural safeguards have to be written in plain language, not legalese, and include a full explanation of all the available safeguards. The Virginia Department of Education has a link to them on their website. The child find and initial evaluation stage leads up to and builds the foundation for decisions about eligibility for special education services. Next, we'll discuss what criteria must be met for a student to be found eligible for special education services.
In Virginia, there are 14 disability categories for special education eligibility. It is important to note that the criteria for each of these categories are different than the criteria for a medical diagnosis. So a child who has a medical diagnosis may not meet the criteria under the corresponding category. Similarly, a child does not need a medical disability diagnosis to fall under one of these categories. The state regulations detail the criteria for each category, and the Virginia Department of Education has created worksheets in the form of checklists based on this criteria. Schools often heavily rely on these worksheets to determine eligibility by selecting the suspected categories and going through the checklists. As a parent, it may be helpful to review the worksheet for each category and request that the school evaluate your child for any eligibility category you think may apply. Schools and parents sometimes get caught up in what category a child is eligible under. It is important to remember that once a child is found eligible under a category, the school must address that student's individual needs. A school cannot deny a student a particular service, program, or accommodation simply because a child is or is not eligible under a specific category.
It's not enough that the disability fall into one of the identified categories. To be eligible for special education, that disability must also interfere with the student's ability to access the curriculum, has to get in the way of their learning. Once a student is found eligible, the IEP team must meet and develop an IEP within 30 days. Please see our website for more detailed information about the IEP process. Thank you for joining us. We hope you found this information helpful. For more information, please see the resources available on our website. You can also find our contact information online.